A new lawsuit targets Governor Roy Cooper's ability to issue executive orders linked to COVID-19. Joining us with reaction to the suit, John Guze. He is Senior Fellow in Legal Studies at the John Locke Foundation. And John, this is not the first time we've seen a challenge to Governor Cooper's emergency powers. What do you think about this latest effort?
Well, you're right. I mean, this is probably the fourth or fifth one, I think, that I've read. And this is an interesting one because it makes a point that I don't think any of the others did, which is that we really aren't in an emergency any longer. Any reasonable definition of emergency, this has to be a situation that is emergent. It's something new and urgent that has to be dealt with immediately. The whole reason we have an Emergency Management Act, the only constitutional justification for delegating these kinds of powers to the governor, because really these are legislative powers, is because this is a situation that's so urgent and that has emerged so suddenly that there's not time for the legislatures to meet and deal with it. So in this complaint, the plaintiffs make a very interesting point, which is that we're no longer in a state of emergency by any reasonable definition.
And in fact, they put forward a number of pieces of evidence to that effect, that there have been declines in the percentage of emergency department visits, declines in daily diagnoses of COVID-19, and a number of other points. That's one of the key arguments. There's a second piece to this complaint, and that is dealing with the mask requirements. Basically, this case argues that mask requirements are unconstitutional, especially when it comes to people who've either had COVID-19 or have been vaccinated against it. What do you think about that argument?
Well, I think that's actually the stronger argument as far as getting a judge to sign on to this. Even though we're clearly not in an emergency under any reasonable definition, the Emergency Management Act gives the decision about whether we're in an emergency to the governor. And I think it's a little hard to picture a court second-guessing the governor on that score. But this is a different issue, and this goes to the whole question of what's the standard of review we should use in these kind of cases. And under any kind of a reasonable standard, there's got to be some logical, rational relationship between what the governor is imposing, the orders the governor is imposing, and some legitimate public health benefit. And really, once people have been vaccinated or if people are immune because they've already had the disease, how can you justify forcing them to wear masks when they're not even vulnerable? That's a more interesting point that I think a court might decide, you know what, this isn't a reasonable relationship between the purpose of the order and the order itself.
And in fact, in the complaint itself, it says the face covering requirement in Executive Order 209, which is one of the governor's executive orders, does not have any rational, real, or substantial relation to the public health. So it'll be interesting to see if a judge will go along with that. Now, regardless of what happens with this latest case, you have been following the Emergency Management Act and the governor's emergency powers, and you think the General Assembly ought to take some sort of action.
Absolutely. Our act is simply defective. It just can't be right to say the governor can declare an emergency, and by so doing, he acquires all these legislative powers, and then he keeps them for as long as he wants. That can't stand. In fact, I think if somebody challenged the Emergency Management Act in itself, on its face, on that basis, they might very well win, because that violates the separation of powers under our state and federal constitutions. The governor cannot usurp the powers of the legislature. And as I said before, the legislature might want to delegate some of those powers temporarily in an emergency, but after a year, we're not in an emergency in that sense, and the legislature can surely meet. They're meeting right now in session. They can deal with this ongoing medical problem in some appropriate way. They don't have to let the governor have the power to do it for them, and they shouldn't.
And in fact, the House and Senate have already approved bills. Neither one of them has become law, but they've approved bills that would deal with this. In the House, there would be a 7-day limit on the governor's orders in an emergency unless the Council of State authorizes the actions to continue, and the governor would have to consult with the Council of State within 48 hours. On the Senate side, the governor could act unilaterally for 10 days, but after 10 days, he'd have to have the Council of State's concurrence, and after 45 days, there would have to be an action by the General Assembly. This sounds a little bit closer to what our constitutional system requires.
Especially the second of those two bills, because it brings the General Assembly, and that's got to happen, I think, for this Emergency Management Act to be constitutional. Even the Council of State It's a very good provision. We want the Council of State involved. We'd be in a much better position today if the governor had done what he was supposed to do under the act and convened the Council of State and had this bipartisan group of elected officials from across the state work together on solving the problem. Nevertheless, at the end of the day, these kinds of this is legislation, and it's the responsibility of the General Assembly to do it, and they've got to maintain that kind of oversight one way or another. So I think the act needs to be revised in a way that gives the General Assembly the ultimate control over whether or not we're in a state of emergency.
As the debate about emergency powers moves forward, and as this new lawsuit against Governor Roy Cooper moves forward, we know one person who will be watching very closely is John Guze. He is Senior Fellow in Legal Studies at the John Locke Foundation. Thanks so much, John.
Thank you, Mitch.